Hello, everyone. Welcome and thank you for joining us for today's webinar, Introduction to Marine License Insurance and Captain's Liability, brought to you by Workboat.com and sponsored by 360 Coverage Pro's Mariner Liability Insurance. I have just a few housekeeping notes to go over before we officially get started today. If you have any technical questions or issues using the WebEx platform, please use the chat box and I will respond right away. If you have any issues with audio, please click on the phone icon above the chat window to receive the teleconference information. For those that do call in, to ensure call quality, everyone's lines have been muted today. If you happen to get disconnected at any time, you can log on again using the instructions provided in your webinar confirmation email. If you continue to experience difficulty, please email webinars@workboat.com and we will respond as soon as we can. We encourage you to ask questions throughout the webinar. Please type your questions into the Q&A box and select all panelists when submitting your questions. At the end of the presentation, we will have our presenters answer questions. And this webinar will be recorded and you will receive a thank you email with the on-demand materials within 2 business days. And with all of that out of the way, I would like to introduce our speakers for today. We have Brian Murphy, Senior Vice President of Berkley Offshore Underwriting Managers, Raul Chacon Jr., Partner at MG+M, the law firm, and Chris Buseman, Program Manager at 360 Coverage Pro's Mariner Liability Insurance. And at this time, I would like to welcome our speakers and hand the webinar over to Chris. Welcome, Chris.
Well, thanks. Perfect. So I thought, let's see here if I can get the slides going. Perfect. Cool. So I thought that before we start diving into the nitty gritty of the presentation, I would give everyone a brief overview of what this or the next 45 minutes or so is going to look like and what to expect. I'm going to start off fairly high level, talking about what our program is, why it's important to anyone who's earned a Merchant Mariner credential, and then touch lightly on some of the more common incidents and things that could happen on board all different types of vessels. My piece of the presentation will follow up with Brian, our program underwriter, who's going to dive a bit deeper into what exactly marine license insurance coverage is, chat through some of the coverage and policy definitions, and then I don't know if I was going here. And then, discuss some of the incidents that happen on board vessels as well. And then definitely we saved the best for last with Raul, who is going to be working us through some actual legal case studies. And we can see what happens when the rubber hits the road and how your policy coverage is triggered or responds to a claim scenario, an incident out on the water, or any types of allegations that vessel operators and captains might face. So here. Okay. I think it makes sense to kick off today with the who, what, where, why, when, and a little bit of the how to provide a little bit of background on 360 Coverage Pros. So our program started with mariners in 2019, just prior to the real impacts of COVID on the maritime transport and trade industries, which we all know way too well at this stage of the game. And in many cases, we're still really not over that hurdle yet. But there is definitely a light at the end of the tunnel. With a younger program starting with an inception in 2019, I know some of you are probably thinking, how do they get so fantastic so fast, right? And that's because 360 Coverage Pros is, just the brand name, but it has really deep roots. 360 is the organization's trade name. Arthur J. Gallagher, who's the 4th largest insurance brokerage in the world. And we insure a ton of different and very similar classes of licensed and credentialed professionals to mariners. Not only is the program backed by Gallagher, but it's also underwritten by Berkley Offshore, who's got 50 years in the business and terrific financial strength. So we had a vision to make the insurance application process as easy and seamless as possible for the individual captain or vessel operator, engineer, or crewman. And we automated the entire process and simplified the questions or the underwriting questions that insureds need to answer. We also initiated the program knowing that we would largely be working with vessel operators who, are working in more commercial maritime employment settings, things like tug and tow, vessel assistance, transportation and barges, passenger vessels, you're largely commercial industry jobs for those who are holding higher scope licenses, higher tonnage licenses, or just higher grade, right? But we also know and knew that there's a lot of folks who just can't get enough of the water, right? So at one point in their career, they might say, it's time to retire, but I'd like to start up a fishing business or run a charter operation doing tours or excursions, or maybe act in the capacity of a captain for hire or a bareboat charter captain. And so there's this vast realm of people out there as well, and mariners who hold the six-pack fishing license or the OUPV license. So we wanted to make sure that we had coverage that was inclusive to every single person who holds any form or grade of a U.S. Coast Guard license. In terms of the coverage itself, Brian's going to end up diving a lot deeper into that, but I'll give the 3,000 nautical mile overview of our coverage levels. And it starts off with license protection and defense. So if there's an incident out on the water and the Coast Guard, NTSB, Fish and Game, or some sort of governmental authority shows up and investigates, and you need to appear before an administrative court or respond to any other types of record requests or give statements, we've got you covered. Even if you're issued fines and penalties, we've got coverage for that as well, and we'll keep your license unsuspended, or at least make the best out of a rough scenario. The second level of coverage we have is civil and criminal defense, which provides you with an admiralty attorney in the event that there's allegations or lawsuits made against you outside of those administrative hearings or reprimands that are brought forth by any type of third party. The third level of coverage that we have is civil legal liability. And if you're found liable for damages and a ruling or rulings are made against you in court, we'll cover those liabilities on your behalf. And the last level of coverage that we offer is called income protection or loss of income. And if your license is temporarily suspended or pending an investigation due to an incident that occurred or that you were involved in, or as a result of an incident, and it could be suspended long time, temporarily, or reduced in grade, we'll pick up your paycheck for a period of time on your behalf. All the levels of coverage can be completely customized online for different levels of liability and different prices. And we also can create preferred packages and tailored programs for employers and fleets, which we have quite a few of already. So the last thing I will touch on is, and I think it's probably the most important here, is that in providing peace of mind for our insureds, is that we have a 24/7 incident reporting hotline. So if you're involved in a shipping casualty or an incident out on the water and you need to reach out to an admiralty attorney immediately, for any reason, you can call into our hotline, which is issued on a card that comes directly with your certificate of insurance, and you can get the support that you need at the onset of any sort of mishap or something that happens out on the water. All right, so I think one of the things that many of you know, but it's still incredibly important as a reminder, is the fact that the Coast Guard has many different core objectives, or they're known as missions. 6 main missions to be exact, and there's a bunch of smaller but equally as important ancillary missions that aren't necessarily listed within the Homeland Security Act. We all know that the Coast Guard heads up maritime law enforcement, security, and similar operations. But the important one for the conversation today and for our intents and purposes is maritime prevention and transportation system management. So within maritime prevention, in that mission lies the Coast Guard's authority as a regulator of the professional credentials that they themselves issue as essentially a regulatory board. So think of any professional who has a license or an exposure to potentially be sued due to not upholding their expertise. For example, a dentist. If I'm a dentist, I must abide by my state dental board's rules and regulations within the profession, which dictates the scope of authority that I operate under. It goes for the same for a doctor, right? Or even someone like myself as an insurance agent. I am responsible for acting under my scope with the state insurance departments that I'm licensed in. And there's not a lot. There's a lot of different parallels, and the list goes on and on. There's lawyers, accountants, real estate agents, but honestly, it all comes down to the same function for a regulatory board that a licensed or credentialed person has, and it's that regulatory board has one primary function, and that includes the U.S. Coast Guard, and it's to protect the public. And so they are the ones who have issued your license or your credential, and they're the ones who have the power to take it away, and then some if they want to or if they need to keep the public safe. So as you can see with the numbers here on the screen, there's a lot of merchant mariner credentials issued each and every year. More than 60,000 in 2019 and 50,000 or so roughly in 2020. And that figure includes everything from an OUPV license to a master's unlimited tonnage. So the Coast Guard is pretty busy. Which brings me to the next few points here, which is basically the elements of professional liability. All four of these need to be present in order for negligence to be confirmed in court against a mariner arising out of an incident or a situation that occurs. So it all starts with duty, and duty is that as a licensed officer, you have or you had a duty to uphold a reasonable level of care toward the plaintiff. If you deviate from your duty of care or your standard of care due to an action or an inaction, then you've committed a breach, which means that now we have two elements of professional liability present. The move from breach into cause is relatively straightforward, and cause or causation is the link that is the link between the captain's actions and the breach and the plaintiff's losses. So generally, the question that gets asked in court is, did the captain's actions run parallel or in accordance with the actions that any other reasonably prudent captain would have taken in the same situation or given very similar circumstances in order to prevent the plaintiff's loss? And that leads us to the last element, which is damages. Damages are generally some form of bodily injury or property damage that should have otherwise been prevented. And again, this is just a very high level overview so that when Raul goes over his slides, it's something to keep in mind as to what happens in the court setting if there is an actual, if there's allegations made against a professional vessel operator or U.S. Coast Guard licensed mariner. All right. This is just all of the reasons that I could think of for needing to contact us, your liability insurance provider, in the event of a claim, or even if you think some sort of legal action could end up being taken against you. And one thing to note is that, notifying your insurance company or calling the attorney hotline doesn't necessarily supersede addressing any safety concerns that might be happening at the onset of an incident, or also your obligation to notify the Coast Guard or to report something to the National Response Center about an incident that had just occurred. So some of these are pretty obvious, right? We've got vessel incidents and shipping casualties, known injuries, and damages. Those are going to be the big three. I think it's fairly understandable in those situations that you'd want to contact your insurance provider if there's something major that happens. But what about some of these other triggers that aren't necessarily directly a result of actual physical damages, but could be linked to physical damages or bodily injuries? They're more indirect. When you're in a scenario in which you're dealing with clients and passengers, for example, if you are a crew of a passenger vessel of any type or a vessel operator on there, if a wrongdoing occurs, or if all that someone needs to do is really perceive that a wrongdoing occurred, captain took too sharp of a turn, and that's the reason why I fell off the rail or I slipped, anything like that, right? So all it is and comes down to is perception. Things like if you receive a legal notice, that's more obvious. You're probably going to want to report that immediately to your insurance company or call into the hotline. But what about something like a non-legal demand, or if you have a heated argument with a client or a passenger, or maybe you receive like a nasty email exchange or something based off services provided. These are all kind of red flags that are hypotheticals potentially for amounting into a claim, but are reasons that you would want to get out in front of it from a legal perspective before they potentially escalate. And we could provide some guidance as your insurance provider as to how to de-escalate those situations and course correct. So that brings me to the next slide here. And this is probably one of my favorite ones because we actually get to dive a little bit deeper into some of the data here, which comes directly from the U.S. Coast Guard Annual Performance Report. And the report's actually published on a fiscal year. So I think it's usually late April, early May, but unfortunately, I don't think we're going to get the numbers, for 2021 in time here, and we haven't, but we'll post them in our next webinar that we do. One of the first things you'll notice is a sharp decline in the number of overall incidents from 2019 to 2020. And being the forever optimist, I would like to assume that the vessel operators here have really, upped their risk management game. And, I think that the decline here is actually probably reminiscent of the pandemic and COVID having an overall impact on the volume of commercial traffic on the waterways, things being greatly reduced in terms of vessel operators out on the water. But one question that does also pop up here and looking at this slide is, what are SMIs? And it's a bit of a list. It's largely going to be death, a severe injury that requires something in excess to first aid, property damage exceeding $100,000, constructive or actual loss of a vessel. So if your vessel becomes completely inoperable, or if it's starting to sink, that would be what that is. And then if there's discharges of oil or hazardous substances, I believe oil is roughly 10,000 gallons. So these are the really scary situations that you're going to want to make sure you have coverage for. But there's a further dive into those numbers here with how many of these are related to actual passenger deaths, critical injuries, and things like that. So we kind of get a better idea of where the rest of these incidents fall, and categorically speaking. So I don't want to spend too much time going over all of these incidents, or a great deal of detail diving into them. But I will say that there is one thing that's probably important, and that's that if you are operating a vessel within navigable waters of the U.S., or if you're on a U.S. flagged vessel, all of these are going to be termed as reportable. And what that means is that as soon as anything listed here within reporting incidents, marine incidents occurs, it needs to be immediately conveyed to the nearest Coast Guard office sector, the Marine Inspection Office, and that's right after any safety concerns are addressed. So all of that being said, I am going to pass the torch over to Brian, who's going to talk about these scenarios, what happens after these scenarios ensue, why your coverage is so important, and how your coverage is actually going to end up responding to a lot of these listed scenarios.
All right, cool. Thank you very much, Chris. And good afternoon. If you're on the West Coast, good morning. Thanks everyone very much for signing in today. So as Kelsey mentioned at the beginning, my name is Brian Murphy. I'm with Berkley Offshore Underwriters. And just a quick outline of what I'm going to cover. I'm just going to go over the roles of our three companies and what our involvement is in offering this licensed insurance product. Then I will get into just a really quick discussion on the overall professional liability market. And then we'll get into some actual cases. Spent a lot of time researching some of the decisions from the administrative law judges after suspension and revocation proceedings were finished. So have some case studies we can talk about. And then I'm going to talk about the exposures that you face as licensed officers and pilots. Then I'm going to turn it over to Raul. He's going to do a deeper dive kind of into the legal side and talk about our claims response and legal response. And then I'll come back and finish up with how we structure our coverages and what some of the options are. So So just briefly, three companies are involved in offering this product. So Berkley Offshore, that's who I work for. So we're a member company of W.R. Berkley. W.R. Berkley was founded in 1967, Fortune 500 company. So our role is we are the insurance carrier. So we developed a product. I've been working with pilots liability and licensed insurance for I guess about the past 15 years, and really over the past few years, have really kind of built out our offerings in this area. So we are the company that is providing the coverage, and we are paying the claims as well. So we would be the insurer. 360 Coverage Pros serves two roles. So they worked with us in the development of the platform, and it's really their platform that we're operating on, and it was customized for our specific program. As Chris mentioned, they are also a fully licensed insurance agent. So these transactions require that an agent be involved. So 360 Coverage Pros serves that role as well. I'll touch on this again later, but for our group options, we're insuring, say, a tug and barge company, or working with some type of trade association or union. If you have a broker or agent that you currently use, we can work with them as well. And MG+M is the law firm that coordinates the legal response to claims made under the policy. So they field the initial call. Chris mentioned the claims hotline. That goes directly to an attorney 24/7. They field the initial call, guide the officer or pilot through the initial situation, questioning, cooperation with the Coast Guard. And then if there are further proceedings or interviews after that, there will be a local attorney assigned that will accompany you every step of the way. So Raul will go into a bit more detail on that. Just a bit of background about myself. I graduated from the U.S. Merchant Marine Academy in 1994. I sailed on two tankers, very brief sailing career, and then got into marine insurance in 1995 with a company called Star Marine, which is a major marine player. It was there for 17 years, and then in 2012, I joined W.R. Berkley to start up their commercial marine division. So just finished up my 10th year here at Berkley. My first ship as third mate, just a quick story before we get started. I caught down in Portsmouth. So I flew down to Norfolk, headed over to Portsmouth, Craney Island, which is a naval fuel depot. Got on the ship in the morning, and it was a tanker. Really just kind of learned the deck, made sure I was familiar with all the systems. I worked on a tanker during my sea year at Kings Point, so it was overall pretty comfortable, but really had to learn the layout of that specific ship. So I had my first official watch as third mate was the 4 to 8 watch in the afternoon, and loading was we were just about done, so we were topping up a few tanks. Everything was going smoothly. About 5:45 to 6, the chief mate came out to relieve me for dinner. So trying to do a good watch turnover, I told him what the status of all the tanks were. And I told him to specifically watch out for a 4 center tank, which was the largest tank on the ship. That was coming up quick. I said, just make sure you watch that. He kind of looked at me and says, I got it. Here I was, the green, third mate on my first watch, telling the chief mate what I needed to look out for. So headed in for dinner, felt a little bit uneasy. In a really quick dinner, stepped back out, and I immediately noticed the chief mate leaning against the house, talking with one of the ABs exactly where I had left him. And then something caught my eye, and I looked over, and there was a geyser of diesel coming out of the ullage cap from 4 center tank. So we had diesel all over the deck, diesel over the sides, in the water. And thankfully, the vessel's containment booms kept it from being from having a huge environmental impact. But I remember thinking that I was going to have the shortest seagoing career of any third mate in history. But then I also thought, well, we hadn't actually been out to sea yet, so it technically wasn't even a seagoing career. But I was going to be back on a plane the same day. Thankfully, the impact was minimal. The chief mate took full responsibility, and we sailed later that evening. But what I took from that is that when you're working on a vessel, things can go sideways very quickly, often through no fault of your own. And you can be in a situation where you're the subject of an investigation and in a position where you need to defend your license and your livelihood. And that's certainly something that I've taken with me and has really influenced the development of our licensed insurance products. Just so real quick, licensed insurance, why there's so few options. So the professional liability for licensed mariners is in a gray area between the mainstream professional liability market and the marine insurance market. So when you think professional liability market, usually think of kind of, as Chris pointed out, doctors, dentists. My wife is a speech pathologist, insurance agents, travel agents. So more mainstream, very large groups that need coverage and are required to purchase coverage. Then you look at the marine insurance market. And the marine insurance market is generally cargo insurance, hull protection, and indemnity. And the marine insurance market generally steers clear of any professional liability. The professional liability market typically steers clear of anything over water or marine related. So you end up with this gray area that doesn't have a lot of carriers offering products. And then within the professional mariner area, the universe of potential policyholders is really small when compared to other lines of coverage. And on top of that, purchasing coverage is discretionary, so you don't have to have a licensed insurance coverage in order to sail, in order to work, whereas, say, an architect or a doctor has to have this coverage to work. So not a tremendously attractive market for insurers to come in because there's just not a lot of potential policyholders. So we did see this as an opportunity, kind of taking our years of experience to put together a product which we think is great in a very cost-effective way and offer an alternative in this market. All right, so what are the exposures for U.S. Coast Guard licensed officers? So a license can be revoked, suspended, or reduced in grade as a result of a casualty involving ordinary negligence. And that's a common theme that we'll see is ordinary negligence. And as I mentioned, I spent a lot of time going through administrative law judge decisions and just kind of going through how these proceedings went. And there were several that stood out at me, so I'm going to highlight a few. One was an excursion boat in Oregon was on its standard run and came close to rowing shells competing in a race, and it was determined that there was not proper communication between the vessels. The captain's license was suspended for 90 days. And I think it's very common to be in very tight, confined waters, whether it's in the fairways approaching Houston Ship Channel, and you have shrimp boats everywhere, or you come across a sailing regatta as the captain of a dinner boat. These things can happen very quickly. In this case, it was deemed there wasn't proper communication, and the captain's license was suspended for 90 days. Another case, the Coast Guard suspended the license of the operator of a commercial assistance vessel involved in a collision near the James River Bridge in Norfolk. And the accident occurred after the vessel passed beneath the bridge and struck the other vessel. And it was determined that neither operator maintained a proper lookout or operated their vessels at a safe speed. And the captain's license was suspended for 36 months. In each of those cases, and I can't tell from the proceeding whether the attorney was provided by the licensed insurer, but a licensed insurance policy would have provided representation and, if purchased, would have covered the loss of income as well. But both of those situations resulting from ordinary negligence. What are some of the exposures for state federal pilots? So I pulled the next two slides. These are excerpts from the Florida statutes from 2021, which govern pilots, piloting, and pilotage. I just chose Florida as an example, but any coastal state with compulsory pilotage will have something similar. So the first slide is what are the grounds for disciplinary action by the board? Failure to make allowances for the foreseeable effects of current, wind, and tide. Failure to obtain or properly use information available to the pilot. Failure to navigate with caution and restricted visibility. In navigating in channels where the depth of water under the keel is less than the prescribed bottom clearance, and excessive speed. Just some examples of grounds for disciplinary action. And then what can be required, or what are the powers of Board of Pilot Commissioners? So it says, in addition to all other powers conferred by this chapter, the department shall have the following powers, and starting with two, to issue and serve witness subpoenas and administer oaths to take testimony, to require holders and applicants of licenses or certificates to submit pertinent information under oath, necessary to determine their qualifications and enforce the provisions of this chapter. When any violation of this chapter or rule promulgated thereunder has occurred, or is threatened to institute proceedings in appropriate courts in this state to restrain and enjoin some action. So those are some of the powers of, in this case, the Florida Board of Pilot Commissioners, but the statutes are similar from state to state. And just another example that I came across in the administrative law judge proceedings. So a tanker with a pilot on board passed an LNG facility in a speed in excess of 14 knots while an LNG transfer was underway. No LNG was released, but the surge resulting from the vessel speed caused an emergency dock shutdown, cargo hose separations, the collapse of the gangway, and mooring lines to part. The administrative law judge determined that the pilot was negligent and suspended his license for 8 months, and also issued a letter of warning to the vessel's captain. All right, so at this point, and I think Raul is having some technical difficulties logging on. I'm going to hand it over to Raul, who's going to go a little bit more in depth on the legal side. I will circle back when Raul's done, and we'll talk a bit more about the coverages. So, Raul?
Thank you, Brian. I hope everyone can hear me. My current situation reminds me of a story, and as an attorney, I guess I like to share stories of a discussion I had with a judge, a maritime federal judge, in a case that I had just filed. And he'd asked me, Mr. Chacon, why is it that every time I get a filing from a maritime attorney, it's always at the worst possible hour and always under emergency situations? Well, that's the life of a maritime attorney. Nothing happens when it's convenient. And that's why, this insurance and the 24/7 hotline that is provided is very important. You have to adjust under the circumstances. I'm actually on a trip right now and was trying to get my video to work and unfortunately could not. So I was forced to adjust under the circumstances. So I'm talking to you while watching it on my computer screen. I'm talking to you via my telephone. By way of background, I'm a maritime attorney. I've been one for over 25 years. I'm board certified. I also have an engineering degree, and I practiced as an engineer for some time before I went to law school. So, my firm, I oversee the entire marine practice group, and we cover all 50 states, including all of North America, South America, Central America, and the Caribbean. And we actually also have an office in Europe. So this first slide, I figured I'd start with something to catch everyone's attention. And a lot of people know, a lot of you probably know about these cases. They're all very high profile maritime disasters. And the one thing that is consistent across all of these cases, and it's something we try to abide by and implement in the way we handle the cases as they come in, is you have to try to control the narrative. Failure to do so can result in a narrative that, or accusations that are honestly false or misleading. Like, for example, the case, the first one we have here, everyone knows or should know, the case of the Exxon Valdez and Captain Hazelwood. He was the captain of the Exxon Valdez during her 1989 oil spill, at the time considered the worst oil spill in U.S. history. He was accused of being intoxicated. I remember when I first saw the news on this, everyone thought, well, he's a drunk captain, wasn't paying attention, and that's what resulted in this loss. So the accusation of him being intoxicated is what they alleged contributed to the disaster. He was eventually cleared of the main accusations involving the intoxication during his 1990 trial, and where he was found to not have been intoxicated. The second one there is the John Cota case on the Costco Buseman. He was the captain. He was a bay pilot when on the November 7, 2007, he was piloting the Costco Buseman that struck the San Francisco Bay Bridge and spilled at the time 53,000 gallons of oil. He was alleged to to have been high on prescription drugs. The attorneys worked hard in that case to get the charges reduced and absolved him of the allegations. He eventually pled to misdemeanor counts and avoided the felony counts. The Michael Davidson matter, that one I actually was involved in, not in representing the captain or the company he worked for, but involved in some of the cargo loss that was litigated in that case. So that case, if you all recall, was involved the vessel El Faro, which was captained by Captain Davidson. This at the time was called the worst U.S. maritime disaster in decades when he sailed the El Faro into the eye of a Category 5 hurricane. Initially, he was alleged to be incompetent. I listened through all of the tapes in that case and was involved in a lot of the litigation. In the end, that narrative was changed. That narrative, although he never came up on any kind of criminal charges, the narrative was changed from one that he was the sole cause for the loss to one where no one could ever really know who was at fault. And then the last one on there is the Costa Concordia matter. That's the Captain Francisco Chatino. He was, the initial narrative on that one was that he was an egomaniac. He was trying to sail close to the coast to show off to some passengers. Obviously, that case didn't bode well for him, and he was eventually sentenced to 16 years in prison. So obviously, the narrative is very important. And controlling that narrative and the defense of any accusations early on is extremely important, as they can eventually drive a criminal prosecution. I talked a little bit about the Exxon Valdez case. Quick synopsis of it. He was Captain Hazel was accused of being intoxicated at the time of the oil spill. However, the attorneys were able to identify and interview early on and secure their testimony from various witnesses, most of which were the crew, that he was sober at the time of the incident, and he was eventually acquitted of the charges related to alcohol. Although 1 year after the incident, he was convicted of negligent discharge of oil, fined $50,000, and 1,000 hours of community service. He currently maintains his captain's license. So that brings us to the first case study that I wanted to talk to you about. And these case studies, at least this first one, it involves a foreign flag vessel, and it doesn't involve U.S. licensed crew or mariners. But I think it serves as a pretty good example of what can happen and the litigation that may follow a certain loss, disaster, where the mariner is involved. In that case, and for purposes, and before I get into it, for purposes of these two case studies that I will walk you through, we've either changed the names of those involved or omitted them where possible to protect their identities. But the case studies are based on true events. The first one here, the Ridgeway Alexander Z matter, stems from the discharge of an oily bilge water into the ocean without being properly processed through pollution prevention equipment. The owner in the case eventually pled and entered into an agreement where they were fined $2 million for maintaining false and inaccurate records related to the discharge of oil per that plea agreement that they entered into with the Department of Justice. In that case, it was alleged that the senior officers flushed oil waste with seawater to dilute and trick the pollution prevention sensors, and then falsified the oil records. The ship in this case was initially detained, but then allowed to sail after posting a large bond. Unfortunately for the crew, who were foreigners, they were not allowed to leave. They had to surrender their passports. The captain in the case was eventually charged with 6 counts under an indictment, 6 counts including allegations of circumvention of pollution prevention equipment, falsified records, obstruction of justice, making false statements, and conspiracy with other crew members. The captain and 10 crew members, as I mentioned, were detained in South Louisiana for 19 months, even though in that case they actually demanded a speedy trial. Most of the evidence in the case was developed via fellow whistleblower crew that videotaped the discharge. So there was a substantial amount of evidence early on, and cooperation between this crew, this whistleblower crew, and the Coast Guard that was investigating the matter. I know from my experience, and we'll talk about it in a little bit, but I know from my experience, getting involved early and in communication with the Coast Guard a lot of times could help control what eventual prosecution or allegations are put forth against the crew members. Eventually, in this case, the chief engineer and the chief officer pled guilty. However, the captain, through his attorneys, put forth a defense that he was not primarily one that was not primarily one of primary lack of knowledge. He defended his case as not knowing that these crew members had actually done this. They had actually made a mistake and were trying to cover it up without or outside of his knowledge. Following 2 hours of deliberation in the case, the captain was eventually found not guilty on all counts. Our next case study involves a revocation suspension of license or a simple collision case. This one's interesting because as I was preparing for this presentation, and my son happened to be sitting next to me, and he turned to me and showed me a game he was playing that asked him questions on different life scenarios, and one of them actually involved a head-to-head collision between 2 vessels, and the question was, which vessel should heave way to the other vessel, which was very similar to this case. Now here we obviously changed the names, and in this case we have Captain Fenderbender, who held a Coast Guard license for 20 years with no prior suspensions or revocations. Now why is that first line item on this slide important? Because this is part of the narrative that counsel was developing early on in the case and eventually laying the groundwork for so that it could be used later on in the case, to the benefit of the crew member. In this case, while the captain was operating his water taxi, the motor vessel Invincible in the vicinity of the Constellation Pier in the Baltimore's Inner Harbor, there was a lot of boat traffic, including taxis and other ferry vessels in the area. He had been operating, and again, another fact that was developed in his defense, he had been operating these water taxis in the Inner Harbor for approximately 10 years. On that day, the Inner Harbor was calm, and it was a sunny, the Inner Harbor waves and sea state was calm, and it was a sunny day with clear skies. Well, Captain Fenderbender traversed the Inner Harbor with 8 passengers and noticed several vessels departing the dock, including the motor vessel Watch Out, which was a 60-passenger shuttle. The acting mate saw the Watch Out depart the dock, but failed to maintain a lookout since he was assigned to collect money from the passengers. And he was obviously on the motor vessel Invincible, and his job was not only to be a lookout, but also he had a secondary job, but to collect money from the passengers. Now, Captain Fenderbender also noticed, and in his case, in the case testified that he saw the Watch Out approaching and thought that the captain was coming toward him to tell him something. This was common practice in this harbor for two vessels to sail close to each other as they were passing, so that they could have brief conversations when passing each other. Now, although the captain felt unsure about the other vessel's course, he did not alter his. And this was testimony and evidence that was eventually worked out during the case. Although Captain Fenderbender did testify that he stopped his vessel, the court decided after hearing all the testimony not to accept some of the testimony provided in the defense of Captain Fenderbender, and instead found that he did not alter his vessel's speed or direction until approximately 1 second before the collision. In fact, the court found that he first increased his speed and then turned to his left or to his port and then to his right or starboard to attempt to avoid the collision. The vessels eventually did collide, causing some minor damage, but some serious injury to a passenger aboard the Captain Fenderbender's vessel. So what did the court eventually find in the case? Well, after hearing from 13 witnesses, plus Captain Fenderbender, the administrative law judge concluded that he was negligent and found that the captain was responsible for the vessel's safe passage, and he had failed to conform to the standard of care required of a reasonably prudent mariner under the circumstances by failing to maintain a proper lookout, failing to evaluate the risk of collision, failing to alter course to starboard, and failing to avoid the collision. These were all violations of your navigational rules of the road. As a result of the findings, Captain Fenderbender's license was suspended for 2 months. So here's where the narrative is very important, because what options did the judge have in this case? Well, typically the judges are afforded with a schedule or a kind of a spreadsheet of potential judgments that they could enter. In this case, Captain Fenderbender was facing anything from 2 to 6 months of suspension, and in fact, the judge was allowed to depart upwards if he could find aggravating factors. But the attorneys in this case did a good job to present to the court via the testimony provided, and that's going back to one of my prior slides where the court recognized that although not accepting the testimony in the defense on certain facts, did accept the fact that Captain Fenderbender had been a licensed captain for at least 20 years with no prior suspensions or revocations. He had plenty of experience in operating in the harbor, and had, there had been a lot of testimony about his good character. A lot of you may think, so what about the negligence of the other vessel? The negligence of the other captain? Why was that not considered in this case, or should it have been considered in this case? Well, that's really of no import. He would likely be facing his own action for revocation or suspension under his own actions. But they're really of no import here, because the judge here is only really truly looking at the negligence of Captain Fenderbender. And the court in the case did note that the purpose of the proceedings is to protect the lives and property at sea against actual or potential danger. It is not to assess blame for the marine casualties. However, the findings, even though the court took that position and made that record, we know as attorneys that the findings by these courts can be later used in civil actions. So that's why it's important that we, one, develop a narrative early, communicate with the investigative agencies, which may include the Coast Guard or local authorities, so that we minimize the exposure to the licensed crew member. So I mentioned that there's possible ramifications on civil actions, and those are through the doctrine known as collateral estoppel. The doctrine of collateral estoppel gives final and binding effect to factual legal conclusions as to matters actually litigated, necessarily and finally decided in a prior action. So what does that mean? Well, if there was a prior action such as the administrative proceeding involving the suspension or revocation of the license, and testimony was taken there, and the party, in this case the licensed mariner, had an opportunity to defend himself or herself during that proceeding, those determinations can and most likely will be used in a civil matter, and the court can find that the mariner, the licensed mariner, is prevented from defending those allegations to a certain, to whatever extent they were dispositive in the prior matter. So that's why it's very important to take heed of what's going on during your administrative proceeding, as same may affect any civil proceeding that later occurs. And we know that the courts have found that the U.S. Coast Guard proceeding satisfied the requirements of fairness and would collaterally stop a defendant captain in a civil action from arguing they were not negligent. So, that's why, quick action in all of these matters is of utmost importance. You need to get ahead of it because, you can be faced with, something as minor as, which is not minor. I don't mean to minimize it, but something from a revocation or suspension of a license that may escalate depending on the narrative, depending on the media coverage, depending on the pressure from outside forces to a criminal matter, and then eventually translate to a civil action. I'll give you a couple of examples. Case I handled not long ago where I was representing the captain and mate in a tow operation that resulted in the grounding of the vessel they were towing. Got some media attention locally, but they were receiving the Coast Guard was receiving a lot of pressure from the owners of the towed vessel to find some fault through their investigation, or lead a charge to find fault through their investigation on against the licensed mariners. We were involved early on, so we were able to communicate effectively with the Coast Guard and their investigative officer, and kind of change that narrative, change what they were getting from the owners of the lost sailing vessel that was grounded, and also by giving them a counter to the information they were being provided. A lot of times, the licensed captain, licensed crew decide they don't want to say anything or say as little as possible. And that is a lot of times on advice of counsel. But let counsel be your mouthpiece. Let counsel be the one that talks to Coast Guard or any investigative agency and try to control that narrative. In the end, there was no revocation or suspension proceeding against the captain and the mate, and the civil part of it was settled amicably. A recent one that came up on our 24/7 hotline involved a captain that was towing some products, some barges, and lost steerage, and eventually had that resulted in loss of the towed barges, striking other property that was alongside that river, causing a good deal of damage. We got the call at the late hour, and we were on the phone with the captain as the Coast Guard was about to board to conduct their investigation. We walked him through what he could, should, and cannot say to the Coast Guard. A lot of times the Coast Guard wants to cooperate. They will preach that they're not there to find fault. They are there to protect the life and property surrounding the incident. So they tend to allow the attorneys to either appear in person and wait for them, or to allow them to speak or appear. Like in that case, I was remote, so I had to appear by phone. and was able to listen in and also advise the captain during his interview with the U.S. Coast Guard. So the claims reporting process, the way it's set up through my firm, there is a dedicated toll-free number that's available 24/7. There's an operator that's assigned to this toll-free number. That operator will take down some preliminary information. We have a team of attorneys, and as I said, we have offices all over the country that are available to talk the licensed mariner through whatever they need to discuss during the initial investigation. And what the operator will do, typically after they get the call, is they'll go down a list of attorneys that we have available and contact one of them, and that attorney will be put into contact with that mariner. If we have an office in the location, we will send someone immediately over there. If we do not have an office, we have a list of local attorneys that we could tap to actually go out and assist as needed. Our job is to triage the situation and make sure that that narrative I discussed earlier is properly in place, and the crew member, the licensed crew member, interest in his license, criminal prosecution, and civil liabilities are covered. So with that said, I'm happy to turn this over now to Brian.
So we're already starting to run over on time a little bit here. We got a few extra minutes, so I'm going to go quickly through the rest of my slides. Hopefully we'll have time for some Q&A. So quickly, what could a licensed officer or pilot be on the hook for? Legal costs associated with an administrative law proceeding, including legal representation, securing and preparing witnesses, preparing of exhibits, loss of income for the period of the suspension, legal costs and damages from civil lawsuits, and legal costs from criminal charges. And I just want to mention one more case very quickly. This was a decision of the ALJ that I read, and the respondent towed so the captain towed the tank barge beyond the boundary line. In this case, they're talking about Chesapeake Bay, without a valid load line certificate or coastwise exemption letter, which is a violation of U.S. laws and regulations. And just quickly, two things stood out to me on this one. First of all, the captain was held responsible for the tank barge not having a current load line certificate. And that's typically the role of the vessel owner to make sure that the vessels are in compliance with all the regulations. But the captain was held responsible for this. So that was one thing that stood out. And the other thing that stood out, it says a total of 6 witnesses, including the captain, testified in this proceeding for the Coast Guard, and the Coast Guard introduced 11 exhibits, and the only witness for the captain was himself. So I think that shows the value of having a licensed insurance policy that can come in, prepare witnesses, prepare exhibits, so you really put your best foot forward in defense of your license. And this is all available on the website. So how the licensed insurance policy responds to these exposures. So we have 5 coverage sections: license protection and defense, coverage for civil legal defense and criminal defense, civil legal liability, fines, penalties, and associated defense costs, and lastly, loss of income. We go up to $25,000 per month with a $35 per day subsistence allowance. Most common claims we see by far are the license defense in the initial representation at the time of the incident. As Raul said, he'll get a call and we will work with the officer or pilot on the scene when we get the call to give them guidance. And then if there are further administrative proceedings, either from the Board of Commissioners or with the Coast Guard, then we will provide representation as well. And loss of income, I think everybody's going to get the presentation emailed to them, but this was a claim that we paid several years ago with the pilot traveling at excessive speed, wake damage to a marina, and license was suspended for 3 months. Loss of income, about $100,000, and legal fees were $100,000 as well, both of which were covered by the license insurance policy. And then this is just some terminology you can find in the policy. You can download our policy on the 360 Coverage Pro's webpage. So, but everything ties back to a shipping casualty. And also in the policy that you can download are the key policy exclusions. So we wanted to certainly be transparent about that. And lastly, coverage options. So individual officers can purchase coverage directly through the website at 360coveragepros.com/mariners. Various coverage options and limit options as well. Can be purchased by the employer as a benefit for their licensed officers to attract and retain employees. Just to mention again, if you're a company and you have an existing broker, you can use that insurance broker. And the company can negotiate discounted rates for their officers or pilots, but then those individuals purchase that coverage themselves at those reduced rates. And for group policy, what we typically see, the company will buy for example, a tug and barge operator, a blue water vessel operator will buy a base policy with relatively low limits. They provide that as an employee benefit, and then give the option for buy-up coverage. The individual officers can then go in and purchase higher limits for the individual coverages for themselves. And a very common group policy combo that we see is license, defense, and loss of income as provided by the employer. So, all right, that was a lot to squeeze in about 4 minutes there. So here's a list of some of the groups and classes of individual officers that we cover. So I will leave that up for a minute. In the meantime, Matt, any questions that, and I'm sorry, I haven't been looking at the chat, just been focusing on the presentation. So hopefully we have time for a couple of questions.
Yeah, sure. Hey, everybody, Matt Puzio here. We are running a little bit over time, so we're going to get to 1 or 2 questions, and then we'll be sure to answer any additional questions offline. All attendees will receive an email with a recording to the webinar, and then also we'll announce the winner of the Yeti Rode 24 cooler. Our first question comes from Dan Spellacy and is directed to Brian. Dan asks, as an insurance broker, we're dealing with business owners as opposed to individual captains. What is the best way to sell this product to the business owner? Could a business owner be pulled into a professional liability claim associated with one of their captains in addition to a standard P&I type loss?
Great question. And so the last slide that I went through talked about what the typical coverage options or with the typical program option that we see, and it's license, defense, and loss of income. So employers oftentimes will not purchase the civil liability because there may be some overlap with the P&I coverage as a vessel operator. So we generally see the group option as license, defense, and loss of income to really keep those 2 exposures separate. And the best way to sell it, we just kind of came across this when we started marketing this program. Employers are purchasing this as a benefit. So alongside like extended disability, life insurance, and license insurance. And, you know, we write whole P&I coverage for a lot of the major operators in the U.S. And the thing that always comes up in conversation as their major challenge is the ability to attract and retain talented crew. So they view this as a tool to do that.
The next question comes from George Berkley. What is a compelling argument for U.S. state ship pilots to carry civil liability insurance? Typically, the ship pilot is covered by the ship's insurance, lacking gross negligence. If the pilot is carrying additional insurance for civil damages, won't they be sued for that additional coverage amount?
That is a really great question. And I know Kelsey is probably looking to wrap up if I could just answer this one question. So we write 11 pilot associations, and the approach to civil liability coverage from the different pilot associations it varies dramatically. So we have some associations that do not purchase any civil liability coverage. We have others that purchase in the tens of millions of civil liability coverage. So yeah, there are a lot of protections, limitations of liability or exemptions from liability. And then on top of that, as you said, typically any liability for pilots are covered under the vessel's hull and P&I policy. However, that is not going to keep you from getting sued and at a minimum incurring what could potentially be significant legal cost in defense of that suit. And oftentimes those could be very high profile suits. I'm not an attorney. I'm not really qualified to speak on whether or not those liability limitations can be broken. I think there's always probably that possibility. Not really seen it happen. And that is a very common view that if we carry the insurance coverage, then they're going to go after it. So that is really a decision made by the individual pilot associations, after they discuss their risk appetite. And like I said, those vary widely. But one thing, I think the common denominator is if you do get sued, you will rack up significant amount of legal fees, which could be covered under a licensed insurance, under a pilot association license policy.
Okay, we'll be sure to answer any additional questions that came in offline. I'll now kick it back to Kelsey with some housekeeping items.
Excellent. Thank you, Matt. And that is all the time that we have for today's program. Just like Matt just said, if we didn't have time to address your questions today, our presenters will follow up with you post-webinar. And I just have a few housekeeping notes to go over before we officially close out today. If you could please fill out the short evaluation form that will appear once you close out of the webinar. This will help us better serve your needs in future webinars. And as a reminder, I've had many people asking me, the on-demand materials will be emailed to everyone within 2 business days, and this will include the link to the recording of today's presentation as well as a PDF of the slides. And thank you again to our panelists for a great presentation today, and thank you to all of our attendees for taking the time out of your busy days to join us. This webinar was brought to you by workboat.com and sponsored by 360 Coverage Pros Mariner Liability Insurance. Thank you all and have a great day.
Thank you, everyone.